a lot, doing a lot for the community through this kind of public service announcement. I'm going to share my screen tonight. Can everyone see that? Okay, great. Can everyone hear me? Okay, great. So the theme tonight is pathways to generational wealth. And we talk about that all the time in different means. You know, people see it on social media. We're hearing about it. We're experiencing it. We are be quite frank with you, this is, in terms of boomers, the largest generation ever of wealth that's going to be transferred in the next 25, 30 years. It's going to be the largest amount of wealth. So before I get into that, I got to get into the lawyer speak. Shouldn't be considered as legal advice, although there's legal concepts that are discussed here, that I'm not here as your attorney. But if you are seeking information, you should consult with an attorney in making any of your decisions. Don't just rely on this presentation because it doesn't capture everything that may be unique to your situation. Presentation is going to be general, and I'm going to primarily focus on Maryland law. All right. So that's enough of the attorney disclaimer stuff. And I try to keep it short as well. All right. 54%. Just by, a show of hands, 70%. Anybody have an idea? You just kind of raise your hand if you have an idea of what 70% represents. If you don't know, this is what it is. It doesn't represent you guys because you guys are here already trying to start and begin your process of estate planning, but 70% of people don't have an estate plan. They have no plan at all. They don't have a will. They don't have anything that is resembles a plan. The 54% represents 54% of people don't have a plan because they procrastinated. So 70% of people, 7 out of 10 of you don't have a plan. And half of that is because you have procrastinated. Tonight, the procrastination has ended. I want to talk real quickly about generational wealth. In the African American community, in the Black community, the makeup of Black people in this country, 400 of the wealthiest billionaires in this country have more wealth than the entire Black population in the United States. And I want this to really stick in with you, that 400 of the richest billionaires in the United States have more wealth than all the households in the United States, Black households. And that's significant because one of the things that we're dealing with when it comes to generational wealth building and all is that we've actually we have just started accumulating wealth really in the last 75 years, right? Because Jim Crow was around for 100 years after the Emancipation Proclamation, right? Where there was legal discrimination. You couldn't live here, you couldn't buy here, you couldn't do certain things, and you couldn't accumulate wealth, right? So you had 100 years of this Jim Crow preventing wealth development. So now we're really talking about 1964 when the Civil Rights Act came in and we started removing certain racial barriers. So it's only what, 60 years? So as a result, we are way behind, but we're catching up. And it's important, how do we transfer this wealth that we're accumulating now to make sure the next generation doesn't have to start all over from scratch? We have to protect family assets, and that's what this presentation is really going to be about. And part of that is, of course, is starting out with promoting financial literacy, which many of you may have done already by having retirement plans, having life insurance, having assets, and understanding how to create wealth for yourself and your families. Now, planning is one of the things that is sometimes difficult for us to deal with when it comes to planning for our death, planning in the event we become sick. But planning really isn't that difficult when it's time for a wedding, a birthday party, or a vacation, right? In fact, all of you plan to be at this webinar right now. You set aside the time, you had it in your Outlook and your calendars, and you knew to come on into the Zoom to hear this presentation. You planned for it, but it's very often difficult for people to plan for incapacity or death. And many of those that haven't planned, they're not planning, they have an excuse that, hey, I'm too busy, too young, it's too expensive. Or if I plan for it, if I plan for my death here, it's likely going to happen. You know, it's one of those things that we sometimes fall into these superstitions of doing something like this will cause our demise. And that's not necessarily the case. Okay. Or that it will take too long. Oh man, it's going to take a while. I don't know how long this process takes, and I don't want it so protracted. I just want to get it done. Doesn't take that long, okay? But if you've waited this long, another 2 to 4 weeks isn't going to uh, be as long as you anticipate. Some folks think that they're not old enough, right? How many people say, oh man, I'm 30 years old, I'm 40 years old, I'm 50, I'm 60. I don't need to worry about this right now. I expect to live here till I'm 80 or 90. And that's when I plan on planning. When, you know, I have dementia or I have a real bad illness, that at that particular time, it's a little too late to plan, right? So the age where people should start planning, believe it or not, is 18. Why? Because at that point, you're an adult. And at that point, even though you're with mom and dad, or you have children, you cannot make decisions on their behalf once they become an adult. So planning, even at that age, and I'll get into it a little bit more, is really the age in which those plans need to start happening. And wealth is all relative. We all have things. We have phones, some of us have homes, some of us have vehicles, some of us have bank accounts, real estate, and other assets. You don't have to have $20 million in assets to start planning, right? So hopefully, for some of you that have done some planning, you know, I'm expecting that some of you hope to learn, have a better understanding of the process, whether or not if you pulled out some online documents, whether it's okay, or perhaps you did something, but it's 20 years old and it's outdated. I'm here to give you some guidance on it, right? Because you're obviously in the right place if you have something or someone that you care about and you want to protect, right? Our loved ones, our families, our assets. Yeah, if you're here and you love someone and you want to protect something, you're in the right place. Because in essence, when we're dealing with estate planning, while, yeah, it's about the assets, it's about how we distribute it, it's about how we protect it in the event we become sick or disabled. But most importantly, it's about letting your loved ones know that you lived up to your promise of taking care of issues, right? We live up to our promise of making sure that we take care of issues. And that's really, really important. I don't know about many of you. Have you heard of the terrible stories of when people pass away and things are not in order? And the mayhem and the confusion. Maybe some of you have been involved in those types of situations where siblings and fighting and other issues and discourse, conflict, and everything else occurs. And that's sometimes because things aren't transparent and there wasn't enough planning in place. So today I want to kind of hopefully encourage each and every one of you to think about, have I lived up to my promise of saying that I took care of it? So what we're going to learn today, you're going to learn the things that you probably already know, but hopefully it gives you a little bit more understanding of that process. Setting up a family emergency plan, understanding what could happen and all the various ways in which failure to plan could end up having you end up in court, how to avoid court, how to avoid a living court, a living probate, as we call it, like a guardianship, or how to avoid probate where the distribution of your assets are handled by the state versus you having a plan in place. The way I'm going to address it is that I'm going to deal with worst possible scenarios and best possible scenarios. Okay. So they're all different scenarios. By way, just so you know a little bit about me, I have a blended family. Um, this is my family for the most part. My mom in one of those pictures, my wife, and my bonus kids and my kids. I've been an entrepreneur and I'm like earlier, Brother Russell mentioned, I'm from New York. So I have a makeup of a family, right? It's not the traditional, just mom, dad, and children, but it's a makeup and a hodgepodge of other people who are important in my life. Just by way of my accolades, as was mentioned earlier, I've been practicing law for almost 30 years. Over the course of the last 11 years, I've done a bunch of different probates, guardianships, estate planning, but really focused my practice back in 2018 into 2019, year right before COVID, and doing strictly estate planning. And so that's what I'm doing. I'm helping people avoid conflict and avoid court and helping educate, inspire, and empower our community to know what they have available to minimize, conflict. So you know a little bit now about me and, rhetorically, knowing about you, who needs your protection? And this is just something for you to think about. Who needs the protection or what do you need to protect? So we'll talk about, as I mentioned earlier, about estate planning is really letting your loved ones know that you kept your promise of taking care of it. But what does taking care of it mean? It means all the various legal documents that are necessary to make sure that when things happen, everything works. So let's start off with our first hypothetical family. Okay. So this first hypothetical family, let's say they're from Baltimore, and we're going to call them the Charm family because it's known from Charm City, right? So in this instance, we have a mom who is expecting in 5 months her third child. It's a blended family, minor daughter from a previous relationship and another daughter from her current marriage, right? So we have three potential children coming into play. We got a newborn that has an unborn child that's coming into play. We have a minor age daughter from a previous relationship, and we have one from the current marriage. Maybe that's similar to your situation or circumstance, or maybe you know someone in that same scenario. In this instance, the couple has no will or no other planning except they've named each other beneficiaries on their TSPs and their life insurance and things of that sort. So mom and mom and stepdad, they also own a home in Maryland and rental property in DC. Unfortunately, in this scenario, tragically, about a year later, mom and her husband die in a ski accident after 30 days of incapacitation. Now, remember, I said they had no legal documents. So we're dealing with an incapacitation for 30 days, and then we're subsequently dealing with a death. And they have their oldest daughter, who's now 16 years of age. Well, guess what? 16 is still considered a minor. And then she has half siblings that are younger than her, right? She has the newest addition to the family, and then she had her other sibling that was slightly younger than her. So what's going to have to happen? There's going to have to be guardianships for these children, for the minor age children, as well as guardianship of the assets. So what does that necessarily mean? So guardianship is when someone has to take over control of or manage either the assets of the person, or in the case of a minor or a disabled adult, take care of that person. In other words, they step into their shoe and they are that person. They take them to the doctors. They handle all of their affairs. They talk to everybody. They make all the decisions. And in this instance, because they didn't have a will, and more importantly, because these kids were minors, there's going to have to be a guardianship hearing for the minor. Now, you can only imagine, remember, one of those children was from a previous relationship. And let's just make the argument that her dad is still in a part of her life. So dad, if unless he has given up custodial rights, will have custodial rights over that child. But he may not necessarily have the right to manage the assets that are left for her. Okay. So, but there's going to be a guardianship hearing about that, because somebody has to be the steward of these assets and be responsible for it. Secondly, remember I mentioned they have a rental property in DC. Well, guess what? Maryland does not have jurisdiction in DC. In other words, Maryland can't dictate how DC property is distributed. So when people own multiple properties in different states and they die and they haven't had a proper plan put in place, they have multiple probates that they have to go through. The other thing, as it's mentioned, since it's a mom and a dad, there's likely, if they have assets that were titled in their names and they had accounts owned separately, dad had his own checking and savings, and maybe he had an E-Trade account somewhere. Mom had her little stash checking account and savings. And even if they named each other beneficiaries, at this point of the matter, they're both deceased. So now you got two separate probates that have to be handled. And going back to those children who were minors, when they have a hearing and someone is appointed the guardian of their assets, right? That guardian now has to report to the court until the youngest turns 18. So for the first one, the 16-year-old, the guardian's duty ends at 18, and they get whatever monies are made available to them at that time. But remember, there was a young one that was just recently born. That's 18 years of reporting to the courts each and every year how those assets are spent. And in some instances, there are certain requirements that the court imposes that says, hey, if you are being steward of these assets, you're going to have to get permission from us if you need to use the money for something else. So it becomes onerous. And if you can only imagine, 18 years of court supervision is a long time. So what's a better solution, right? What's a better solution? Well, they could create a will and name guardians, right? So why would we name guardians? Because perhaps, let's say, for the eldest of the minor children, the 16-year-old, let's say her dad, he does get custody, right? Because that's his daughter. But he may not be the guy who mom would have wanted to handle the money, because she may feel that he just was not responsible, and maybe he's not. So by naming guardians, you get the opportunity ahead of time of saying, these are the people who we trust that can handle the responsibility if something happened to us. And these are the people who we think would be responsible enough to follow our direction of raising our kids, be it religious preferences, the type of schooling, the type of extracurricular activities. So it doesn't, again, prevent, having a will doesn't prevent probate, and naming a guardian doesn't mean that that it prevents court proceedings, but it gives at least the court guidance, especially in naming guardians, who the parents really trusted and wanted to serve in that capacity. And that has a whole lot of weight than somebody coming in and sounding good before a judge who knows nothing about your family. Okay. In a blended family, as I mentioned earlier, one of the parents may still be alive and has parental rights. Or another solution is that you've established a trust, and I'll explain what that is later on. So the kids don't get all that money at 18. Let's say there's $1 million in assets, you know, and each kid gets their portion at 18. So at 18-year-old with $333,000, that's quite a bit of money. I don't know about you, but I know when I was 18, if I had $333,000, it would be it'd be a party all the time until I ran out in about 2 years, right? 2, 3 years. So that's something to think about when you're naming or leaving assets and there are minor children involved. And of course, one of the things that this trust would have been able to do is keep the properties in place until it was time to be disposed. And that plan could have included who'd stay in the marital home and make sure that there were adequate resources so the kids don't get displaced, right? I mentioned about a will. So what is a will? It's pretty simple. It's a legal document that outlines your wishes. In Maryland, you name a personal representative, and some folks refer to it as an executor, but in Maryland and DC, it's known as the personal representative. That's the person that, when you die, handles the administration of your estate being everything that you had owned in your name, not jointly, but solely in your name. Your clothes, your computers, your furniture, things of that sort. They help ensure that the assets are managed and distributed according to your wishes. That's what a will does, okay? Without a will, then the state has a will for you that may not necessarily be what you want. It can help, obviously, prevent conflict that can arise amongst family members. Timing of when you do your will is very important. If you're doing your will and you're incapacitated or you have cognitive decline, you're in the midst of dementia where you don't even remember 2 minutes ago, that could be challenged, okay? Because you're not of the proper state of mind to make these decisions, especially if you can't remember what you said a minute ago. This is very important to understand. But the earlier you do it, and where you are of your right state of mind, it's clear that your intent is what it is. So you got to be at least 18 years old to do a will. You got to have the capacity of what I said. Now, remember, we talked about this. I mentioned about the person with dementia. So I get a lot of folks who come to my office and they bring their elderly parents. And I always, because of client confidentiality and things of that sort, I always tell those individuals to step out of the room unless their parent agrees that they can participate in the process. And when they're elderly, one of the things I do, I just have a conversation with them. I want to know about their street address. I want to know if they know their date of birth. I want to understand the relationship of their children. I want to know if they even know their children's names. And I may go back to that and things of that sort, because it's important for me to understand the capacity, but it's also important for me to understand whether or not the children that are bringing them in are influencing them. In other words, mommy, I'm here for you and everything else. You need to just leave the house to me because my brother, he, they start bad mouthing their other sibling. Oh, he's never around. I don't get no money from him, blah, 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 blah. So I need to understand that this adult has the capacity and is not under any influence to make decisions. So it's very important. The other thing is that a will has to be signed before two witnesses, and a beneficiary or anyone that can be deemed a beneficiary cannot sign. I don't let them sign the wills at all. Okay. So it needs to be signed. Let's go into scenario 2. And I'm more than happy to answer any questions along the way as well. In this instance, we have a dad with a minor son, similar to the one before, but dad, he's works in the DMV, stable career, active in his community church, several fraternal and civic organizations. He remarried a year ago. Okay. So again, he owns and resides in his home in Maryland that he bought prior to marriage, remarriage. And he also owns a condo with two of his siblings in DC that they rent out. He has a minor son, 15 years old, from previous relationship, and the son lives with dad. Dad, he has TSP, 401k, IRA. He's around. He's been in government and outside of that, and has accumulated some assets. He has a $500,000 life insurance policy. This man is a prudent man. He has assets. He has responsibilities. He's insuring everything. He's even got a will. And he's named his brother as personal representative and guardian of his son and assets. Well, unfortunately, going home from a work-related event, dad dies from injuries he sustains in a car accident. He has a will, of course. There's life insurance from work, and his auto policy pays a death benefit. And dad's brother, as personal representative, is meeting his responsibilities. He opens up a probate estate with the courts to settle his affairs, right? And, as parents do, and this is his only son, he leaves everything to his minor son. Again, naming his brother as guardian of the financial assets. The problem is he got married last year and forgot to, update his will to include his current wife. Now, gentlemen, you can see that's a problem. But it's also a problem for, um, uh, a spouse, right? I don't know what happened here. Something, I don't know what that is. Okay. So anyway, we got a 15-year-old. He's going to receive all this money when he's 18. Now, we already know $500,000 in insurance, got a house. It's a whole bunch of things, but it's not as easy as it looks, right? He's a nice kid. We all know him. He's not yet responsible to handle that large inheritance from the life insurance and death benefit. And guess who is still in the picture? His mom. And his mom now is saying, she hasn't given up her parental rights, which is fine. But now she's challenging the uncle, the brother, about managing the money. So now we have a court conflict, even though he named his brother as guardian. So sometimes it can become conflicts too, because mom feels like, well, why is he managing the money? I don't think he's capable of. I think he's a drunkard. He's this and that and the other. So now she's going to create some conflict. And also, dad's current wife is going to create some conflict. Why? Because she was totally left out. And so she's going to go and talk to a lawyer and say, hey, look, my husband died. He left everything to his minor age son. We were married. Do I have any rights? And that lawyer is going to say, well, yeah, when did he die? He died 6 months ago. Well, yeah, you have up to 9 months to make what is known as this elective spousal share, which means that you're entitled to at least a third of those assets because he had a minor child. He had a young child. He had a child from a previous relationship, and it was his child. So you're at least entitled to 33% of the assets, the total assets. So she's relieved, right? So it's important to understand to have a good plan because one, now we're having a distribution going outright to this 18-year-old. We have some real property because remember, he owns a property with two of his siblings. Now, it depends on how it's titled. Suppose it's titled joint tenants with rights of survivorship. That means that whoever survives, they get the interest of the person that passes. And that works out nicely. But let's say they weren't titled properly and it was joint tenants, tenants in common. That means now the siblings that own that rental property now have a possible interest with their deceased brother's wife and nephew. That could be complicated. They may not want that, but that's what happens. So joint ownership of property sometimes makes sense, sometimes it's not necessarily good. It exposes folks to creditors, and with a minor, they still need a guardian to sell their interests. And when you have joint ownership of things, obviously, you can't do as you please, right? Everybody has to be in agreement. And then, of course, with the multiple homes in the different states, as we just talked about, there would be double probate. So a will, as we're just finding out, it doesn't avoid probate court. It still causes some challenges in that scenario. Just going to go through, there's probably some familiar images here. The Migos, Takeoff from the Migos, died about a year and a half ago. No children, no will. But because he had no will, and this is my point in this, his mother and his estranged father had to split those assets 50-50. Mom fought it in court, but the way the laws were in Georgia, they get it 50-50. We all know about the Queen of Soul. We know that she had, at the time, I think I did this was 4. I think there was another one that appeared of a will. Here in Maryland, we don't go with handwritten wills. Everything has to be in type. You could sign. They call holographic wills. Those are only available for people who are active duty overseas, and they can do, at a time of war, can write a will, and when they get back, they got 6 months to get it back in order. But in this instance here, the handwritten will or the DIY type planning didn't work. We all know Prince didn't have a will or a trust, but most of the conflict came. He had half brothers and half sisters, and most of the conflict came from the IRS wanting to value the properties, his assets, and his estate at a certain amount. The point of the matter is, even though they had no wills, or some had a will, he still end up in probate court. In Maryland, it's known as orphans court. And in that process is at least 9 months. It could be years after that, 2 years, 3 years, because the process requires having an account, reporting to the state approving. And when I say the state, meaning the courts approving those assets. The other problem with probate, which a lot of people don't realize, if you go to marylandregisters.gov and you do an estate search, you can pull up anybody's estate that has died. And with 50 cents a page, you could print out every single thing about it. You can know who you could read the will, you could see who the beneficiaries are. You could look at the inventory, the accounting, and see how much a person is going to receive when the distributions are made. Problem with that is that it's open for predators to, find out, look at the obituaries, find out who died, and see how much money people are getting. So probate is a public process because it's a court filing. It's a long process because it takes a minimum of 9 months. It can be an expensive process because as an attorney, we're happy that the state statute provides for, on average, 3.6% of the value of the estate over $20,000. Well, guess what? You have a house that's 500,000, and maybe you have $200,000 in other assets and everything else. You're talking about $700,000. Well, you multiply that by 3.6%, you're looking at about $22,000 to $23,000 in attorney's fees. So that the statute provides for, right? Now, a judge can make a modification to it, but for the most part, the statute provides for that. So it can be very lucrative for attorneys, for folks to go through probate, but it's certainly not the best thing for them, right? So in this instance, probate was regarded, for this particular hypothetical, but maybe something is better for it. One of the things that he should have done was plan better for his new spouse. So at the very least, he should have made sure that that spouse had at least the minimum under an elective share, right? Um, because he can't disinherit her. The only way he can, quote unquote, disinherit her is, let's say he had a prenup, or maybe they went through a postnup, or maybe she signed a waiver from that. But those are the only ways in which you can release somebody from making a claim against your estate, who is your spouse. In this instance, he had a lot of assets that he brought into that marriage already. And maybe it would have been prudent that they had a prenup in place. So this way they could have agreed, hey, these are my assets prior to us, and this is how I want to distribute it. And those assets we acquire together in the event of something, my death or something or another, hey, or divorce, these assets are what we would share. That could have been one solution. He could have established a trust or other type of manner to transfer their assets without going through the probate process in two jurisdictions. And importantly, with the biological mom, communicate with the stakeholders. Maybe he should have kept her in the loop, right? Especially if he's making a call as to who's going to serve as guardian of their child. Not necessarily on the finances side, because that may have been unavoidable, but he had named his brother as guardian of his son. So one of the things, of course, is to review your estate plan. So when there are significant events, you can, plan accordingly. And number one, do not name minors as beneficiaries, because when you do, understand that it's going to be under court jurisdiction and supervision, and those children are going to receive the full enchilada when they turn 18. So we said, what's a trust, right? I've been talking about a trust. What's a trust? So a trust is really a contract that are made between three parties. And sometimes you're the three parties. Or if it's you and your spouse, you guys are the parties to this trust. So what is a trust? A trust is a contract that says, and let's call it the ABC Revocable Living Trust. What it means is that, one, when I use the term revocable, it means that you can change the terms at any given time. You could revoke it, and you can amend it, and you could do anything you want with it. An irrevocable trust is a trust that you can't change the terms as easily as you could with a revocable one. And there's some nuances and things of that sort. But for today's purposes, we're going to talk about a revocable trust and how it helps you prevent probate court. It does a whole lot of other things too, in terms of asset protection for your beneficiaries. But for this purpose, it requires three parties. And those three parties are the grantor or the settlor. That's the person. Think of this, if you could see it. I have a pen in my hand. Well, it magically appears and disappears. So if I put this pen into a trust I created called the ABC Revocable Trust, I have become the grantor of it. Okay, I granted an asset towards it. Could be your home, it could be any other kind of asset, your bank account. And in the meantime, you need a trustee. So what does a trustee do? No different than what a personal representative does, except while you're alive, a trustee manages the assets the same way you do with your bank accounts today. You write a check when you want to write a check, right? You can sell your house. If you own your house with your spouse, you and your spouse say, hey, time to sell the house. You guys sell the house. If you own the house by yourself, hey, I want to sell the house. I want to knock out that wall. You're the trustee. You're able to manage and do as you please with that asset. And then number three, the third party involved with a trust is the beneficiary. While you're alive, remember that pen I talked about? Well, while I'm alive, let's see, I could use this pen. I could use it for whatever purposes I want. I benefit from using it. I own my house. So while you're alive and you have your home in the trust, you benefit. You're the beneficiary. You could do whatever you want. I want to paint the house green. I want to paint unless it's HOA and stuff like that. But you get my drift. You can do what you want to do with your asset. So with a trust, why doesn't it go into probate, Carl? It doesn't go into probate because a trust lives, so to speak, in perpetuity. It doesn't die. It is a entity, it's a structure that's created by contract. So the reason we go into probate as individuals is because we end, our lives end. And at that point, when our lives end, all of our final um, uh, things that we have in our lives have to be administered and distributed. Whereas with a trust, that's not the case. We would then name a successor trustee, and that person would be able to manage and handle those assets. So, what kind of things go into a trust, right? You retitle investment accounts. You get your bank accounts in there. You can execute the deeds to your real property. You could transfer stocks, bonds. Um, Typically, you would change the beneficiary designation to the name of the trust. But why would we do this? Because what it avoids you to do is going through probate. So remember, we talked about a will, and not having a will ends up going into probate. With a trust, there is no probate. It is handled privately. Remember, I talked to you earlier about if you go to the marylandregisters.gov site and do an estate search and you look up somebody that passes away, you can see what the will says, if they have a will or if they don't have a will, you can see how the assets are distributed and who would receive it. With a revocable living trust, that is private. That is not recorded with the government. They don't get to know your business. They don't get to know who's receiving these assets and how. In fact, in some instances, your trust can live beyond some of your beneficiaries. Depends on how you structure it. The point of the matter is any distributions that are done are typically handled in the home of the person who's the trustee, or if they come to a lawyer's office to get some clarity, they can handle those things administratively there and not have to deal with public intervention. And what happens, obviously, with a trust is that it also provides for um, uh, provisions for you while you're alive. So, unlike a will, a trust is active while you're alive. It has disability provisions as well. So, if you become sick or disabled, right? Your person who you've named as a successor to step in the event of your sickness or such can handle those affairs for you without having to have court intervention as well. People put their homes into trusts in multiple, especially in multiple jurisdictions. So this way you minimize those multiple probates that we talked about when you have a home in DC, Maryland, South Carolina, and Georgia, right? It's all in there and it can be managed by the trustee accordingly. If you have minor children, it can be distributed. You can decide at what age and what time and when things like this could be distributed. You can then also not necessarily distribute it to anybody. Keep the home as a family home down the road. Nobody owns it except the trust. So what you can do instead is give folks a right of occupancy. In other words, hey, you could live in the home until you die or until you move out, but you don't have title to the home. The trustee manages it, pays the taxes, pays the administration, or maybe you do the same. But this home stays in our family until whenever. So those are some of the benefits of it. Brother Russell, I know it's 7:46. I'm only on scenario 3. I do want to at least address um, uh, power of attorney and healthcare real quick. Okay. So in this scenario, we have an adult, older couple. They've been married 40 years, 3 adult children, 4 grandchildren. their oldest son and wife has a wife, 10 years married, 3 children, stable life, resembles his parents. They have a younger son with 1 child with his fiance. Unfortunately, he makes rash decisions, doesn't handle finances well. And they have a daughter who just completed cosmetology school and is trying to get herself established. Um, Richard and Alice would like to have funds available for their grandchildren to attend college, but they don't have any legal documents in place for that. And he's recently been diagnosed with prostate cancer, and she's showing signs of dementia. I try to keep it realistic because a lot of us face these encounters in our lifetime. Okay. So let's see. One of the things that we need, what can we do to help, what can we do to help Richard and Alice? Well, number one, they need living documents that'll help them out. Healthcare power of attorneys, power of attorney and advance directives, sometimes called a living will. Look, back in 2020, people realized that by not having these documents, they were kind of messed up because the courts were closed. So you couldn't even get guardianships or anything of the sort, except for a very long time. And it wasn't until they figured out, okay, we could do these things through Zoom, but the process was protracted for a long period of time. And when you're dealing with emergencies and you're dealing with people and loved ones that you need to handle their affairs, it was very difficult. So having a healthcare power of attorney is really important. That gives a person who you trust the responsibility to say, hey, like I have for my mom, if I need to talk to her doctors, they know to contact me. They talk to me and everything else. And I say, hey, mom, I think we need to go and see this doctor or whatever. She gets sick and tired of that. But we we go and we see, and I have the ability to convey and talk to them. I have the ability to get her medical records if I need to. If I didn't have these things in writing, I wouldn't have that power or authority. Power of attorney is similar to that. It is almost similar to, um, you know, having a trust, um, except it does give you certain power. Well, for them, I'm sorry, the power of attorney for Richard and Alice would serve in the purpose in the event they become, as they're aging and going through these medical changes right now. And let's say Alice is at the beginning stages of her cognitive decline. Maybe she's knowing she's losing her memory and things of that sort. Now's the time more so than ever to get her a power of attorney, get Richard a power of attorney, because their health is likely to decline. Richard may not be, but if something happens and they become incapacitated and unable to, they have children, 3 adult children, who may or may not agree on the process for them. Okay. The other thing is for them, they want to leave assets for their grandchildren. A trust obviously is a good way of doing that. It's also a good way of making sure that their son, who may not handle finances correctly, a way in which they can distribute those assets to him in a prudent manner so he doesn't spend it all. All right. Um, just want to talk about a living will, advance directive. Let me see. I'll go here. So an advanced directive, what is an advanced directive? When a person is either terminally ill, vegetative state, end stage condition, those are where a doctor has certified that death is imminent, that you're unable to know yourself or the people that are there with you, or you're on the natural course of death. There are decisions that you have to make about how you want your life to end. And there is a bill currently right now. It's called, I want to say it's the Elijah Cummings and some other kind of another person's name tied to this bill, where they're thinking about people having aid in dying. An advance directive isn't that. An advance directive is, hey, if I'm in this condition, this is how I want my life. This is what I want. I want no nutrition. I want natural death to occur, and I don't need medical intervention. And it's easier for you to make that decision than your loved ones when they're in an emotional state trying to figure it out. So I'm just gonna kind of speed up through the end because we're right here. The main thing is on building generational wealth, you got to do proper estate planning to leave a legacy for your loved ones with, you know, obviously with proper planning, ahead of time planning. Because sometimes if it's too late, it becomes confusing and conflicting. Uh, more importantly, about leaving your legacy, it's your insights, your stories, your values, your experiences. And one of the things that we do is that we do a legacy interview at the end for our clients that choose to do that, where we sit down and we say, okay, you want to do a video? We encourage them to do videos and things of that sort, because at the end of the day, your loved ones who are benefiting from this down the road, they need to know who you are and what your values were and what your insights were because they have benefited from it. So that's it for me right now. Oh, at the end here, if you have your phone, you want to schedule a 15-minute consultation, click put your phone on it and you can link to my schedule. So if you want to do that, feel free. I did put my contact information in the chat as well.
Anyone, are there any questions?
Right here. Actually, thanks a lot, Brother Chen, for this presentation. This was very informative. As a matter of fact, I went through just about everything that you mentioned on here.
Wow.
Yeah, probably within the past 5 years. So I had pretty much my mom and my dad passed around the same time. So my sister and I, yeah, so we had to come about with a power of attorney, and then but my question though is because right now I'm living in the property of my parents, and so what I want to do is do a trust, pretty much have everything in a trust, so that if in fact something happens down the road, I don't want any intervention or anything to interfere with like probates or anything like that. I just wanted to keep it within the trust. So how do I go about, or is, like I said, is that still through the attorney to set all that up, or is that something that I do outside of maybe through some documents or things like that?
Well, Brother Jackson, I don't know how much experience you have in creating trust. Uh, so I say that I think, to me, sometimes very complicated things like this do require, legal advice, legal experts to be involved. There are a number of different legal documents out there, but you don't know what works, and there's a lot of legal terms that are used that may not, it may sound like it's the appropriate thing for you, but it may not necessarily work the way you want. I'll just say real quickly, last month I went to visit my mom. It was an easy plumbing job, and I mean it was easy to do. She's in Florida, and and they have these cheap CPVC type pipes that are, and their outside walls are cylinder. So as I'm attempting to fix it, because I knew what I was doing, even the plumber who I eventually called said I knew what I was doing. The problem was I broke the pipe within the wall. They needed to come in and, so my whole point of the matter is that sometimes we may know it, but then when we screw it up, it costs us more later on. So, feel free. I left my contact information in the chat, and, more than happy to talk to you about it.
Are there any other questions? And we're welcoming questions at this time.
Cynthia said, I came for the info about managing real property, real estate. Did that get out short because of time? Yes. So what exactly is it that you are asking? I don't know if she's still on.
Cynthia, are you still?
Hold
Right.
on. I just wanted to hear what you were presenting. I have a multi-unit property. I've had it for about 20 years and I am trying to transition out of that and was just interested in hearing what, you know, what you had to offer or what, whatever you were going to be presenting, but that's
Yeah,
the
it was more in terms of transitioning properties into a trust as opposed to how you manage your property. If you're looking, I don't know what do you mean by transitioning. You mean selling it?
yeah, getting out of the landlord business and either uh turning it back into a single family home or selling it, yeah, whatever the case
You
may be.
prob-
I live in DC, so
Okay, you probably want to talk to a real estate attorney that will give you some more advice about those issues because since you have your property in DC, one of the things that you may face with tenants is that I think they have a right of first refusal in DC for properties, but you definitely want to talk to someone that deals with more landlord tenant matters.
okay, thank you.
You're welcome.
Are there any other questions? Feel free. Well, I'd like to thank everyone for attending this Zoom call. I would like everyone to know that we here at the Bowie Mitchellville chapter of alumni chapter of Kappa Alpha Psi, what we're doing, we're looking to do our part in sharing and embracing and uplifting our community. And I thank you all for attending this call. We have other upcoming public Zoom presentations where right now the Senior Kappa Committee, I'm the chairman of that committee, we're having upcoming public presentations. And as you see here on Thursday, March 14th, Pi Day, what we're doing, that's a little inside math joke. But anyway, we have Carl Brown. He is a state and executive director of the District of Columbia Small Business Association, and he'll be speaking to us about resources to assist small businesses and entrepreneurs. Then on Tuesday, April 9th, we have a Dr. Camille White, and she's a medical doctor, and she's the CEO of Inspired to Evolve. She's a career coach, and she's going to talk about identifying and leveraging the hidden market. I tell you, I had a short conversation with her, and she brought that up, and I'm like, what is the hidden market? And she said, well, there's more than one way to get a job. If you're looking to work part-time, if you open a part-time work for a full-time position, you could probably negotiate that. You can also probably negotiate other types of positions. So she'll talk about that during this session that is coming up. I want to also point out it's Black History Month. And we're making Black history right now because you attended this call and you're looking out for your family and your generations to making sure they have a history. So I want to thank everyone. I want you all to have a great evening. And I'd like to see you all on March 14th and April 9th. Thank you.
Thank you.
Thanks, Brother Chen.
Thank you. Great
Thank you.
presentation.
Thank you,
Thanks,
everyone.
Brother Chen.
Good job,
Thank you.
Brother Russell.
Thank
Thank
you.
you. Thank
Bye.
you.
Right.
Good job, Brother Ken.
Thank you so much.
You're welcome. Thank you. Brother Chen, thank you so much for your time. Thank you.
Man, it's my pleasure, man. Thank you so much for inviting me to
Okay.
serve. I feel fulfilled in serving the community, man.
And we'll see you at the chapter meeting.
Yep, I got it down here. Bye, Noop.
I knew.
All right, brothers. Yep.
Good night.
Good night.